We're just starting the broadcast in 1 minute. Good morning, teams. By the time we begin, you can please turn on your videos. Okay, hello, good morning, everyone, and welcome to the final rounds of the Lawctopus second online mood competition. It feels truly special to stand here today with all of you, and I totally understand what sort of journey it has been. We started with 50 teams. The entire competition was filled with a lot of research and arguments and counter arguments and long hours of preparation that I'm completely sure of. And it has brought us to this moment where judges, the top two teams here are ready to battle it out for the championship. So, to our finalists, first of all, congratulations. You guys have showcased exceptional skills in the last 3 days, and I've seen that exceptional skills, a lot of resilience, and the dedication to reach to this stage. And I said it a lot in the last 3 days, but I'll say it again that it is not just about winning or losing. It is about sharpening your ability to think critically, argue properly, and most importantly, to grow as a legal professional. So the effort that all of you have put in over the last 3 days, it's commendable. And regardless of the outcome today, you all have already proven yourself in these final rounds. We are also very much honored to have with us our esteemed judges whose wisdom and whose experience will make this final round even more meaningful. So it is with my great honor and with a lot of gratitude that I welcome our esteemed judges for the final rounds. First, it's our privilege to have with us Professor Dr. Yogesh Pratap Singh. Sir is an distinguished academician and administrator. He has made extensive contribution to legal research, particularly in judicial dissent and voting patterns. Sir has served as the Deputy Registrar at the Supreme Court of India to leading NLU Odisha, and now Sir is the founding Vice Chancellor of National Law University Tripura. Sir, we are truly, truly honored to have you with us
Thank
today.
you.
Um, Next, we extend a very warm welcome to Mr. Anu Prakash Avasthi, sir, a self made legal luminary whose journey from economics to law is nothing short of inspiring. Sir is an advocate on record at the Honorable Supreme Court of India for almost a decade now, and he's a registered insolvency professional. And his expertise in the field of litigation, it is unparalleled. And sir, we're truly, truly privileged to have you as a judge today in our
Thank you,
panel.
Mansi, for such generous introduction. Thank you so much.
And we are also delighted to welcome Mrs. Akanksha Mishra, a dynamic leader, a legal educator. She is the Chief Executive Officer at at Lawctopus Law School, and she has played a pivotal role in shaping the future of legal education. She is an independent litigator at the Bombay High Court Nagpur bench, and she's a recipient of Business World Legal's 30 Under 30 award. And her achievements, they stand as an inspiration to all the young legal professionals. Akanksha, truly an absolute pleasure to have you with us today.
Thank you so much, Mansi. Thank you so much. All the best, everyone.
So, judges, any words of encouragement you would you want to share with the participants with before we formally begin with the rounds?
I think I would say please stick to time and your the best strong points. Good luck. All the best.
What I see, LMC 47, LMC 26, that means approximately 50 teams were there. So
50 teams.
yes. So you are on the top. So try to be on the top again. It is not who's going to win or lose. It's not about that. You are already on the top. So all the best. Yes, let the show begin.
I would also like to say
Right.
that, I mean, all of you have done really well, and hence you've reached here. It doesn't matter who wins, but here's to pushing boundaries both in and outside the courtroom. So, all the best, everyone.
Heartfelt gratitude to our esteemed judges for taking the time to guide and judge these rounds. I'm very sure your insights and your experience will be really, really helpful and insightful for them. And also to everyone who's watching, whether you're a participant, if you're a mentor, or you're a law enthusiast, these final round, it's not just about a competition, it's also a celebration of learning, of legal reasoning, and the spirit of advocacy. So, with that, if the judges permit, if you think that we are good to begin, then we will formally start with our final rounds of the
Yes, yes,
competition.
please go ahead.
All right. So, team, all the very best. You all are winners anyway. And yes, so speaker one for the appellant. I'll also give you the screen share rights. Speaker one for the appellant, over to you.
Is the council clearly audible and visible?
Yes.
Loud and
Much
clear.
obliged.
Yes.
Much obliged. Before beginning, the council would just like to draw the attention of this honorable court that the appellants have prepared a compendium for all the cases that are being referred to during oral pleading. And if the honorable court permits, the councils would like to share the compendium so that they will display the same.
Yeah.
Sure.
Much obliged. Greetings to the honorable bench. The council acknowledges the gracious presence of the honorable bench. However, for the simplicity of proceedings, seeks permission to collectively refer to the bench as your lordship.
Yes, please go ahead.
Please go ahead.
Much obliged, your lordships. If it may please this honorable court, this is counsel appearing on appellant on the behalf of Dr. Mehta in the case of Dr. Aditya Mehta versus State of Himachal Pradesh under Section 4151 of BNSS. The present counsel will take up 14 minutes and issues 1 and 2, and the co-counsel would address issues 3 and 4 in 14 minutes as well. If it may please this honorable court, the council requests to elaborate on the statements of facts.
Briefly.
Briefly. Much obliged, your lordship. At the heart of the matter lies the death of Mrs. Kalpana Dhumal, who was found dead on the morning of 15th April 2024. She had recorded her wish to die and was suffering from ALS. Her living will was dated 12/9/2019. Dr. Aditya Mehta, a reputed anesthesiologist and palliative care specialist who advocated for the rights of terminally ill patient, filed a petition to the High Court on her behalf for legal euthanasia. However, the petition was rejected on 10th April 2024, and this appeal arises out of the gross miscarriage of justice as he has been implicated. That is, Dr. Mehta has been convicted on murder on the grounds of murder, destruction of evidence, and criminal conspiracy purely based on circumstantial evidence. If your lordships are pleased with the facts of the case, the council would like to address the issues at hand.
Yes, proceed.
Much obliged, your lordship. The first issue revolves around whether the trial court erred in the conviction of Dr. Mehta for murder, criminal conspiracy, and destruction of evidence. And it is humbly contended that the trial court did err for the conviction of Dr. Mehta, and this contention will be based on 4 major grounds. Firstly, there's a lack of direct and substantive evidence to convict Dr. Mehta. Secondly, there are inconsistent testimonies that have compromised the integrity of the trial. Thirdly, the plea of alibi in the present case of Dr. Mehta is airtight. And fourthly, the prosecution has failed to establish the requisite elements of criminal conspiracy. The first leg of the argument goes as follows. There's a lack of direct and substantive evidence to convict Dr. Mehta. Now, it is a settled principle it is a settled legal principle, and it has been upheld by the Honorable Apex Court in cases like Sharad Birichand versus State of Maharashtra, 1984, that Circumstantial evidence must solely point to the guilt of the accused, and it must form an unbroken chain of circumstances. And if there's any alternate hypothesis that exists, the accused must be given the benefit of doubt. This was also upheld in case like Hanumant Govind versus State of MP 1952 and Kishore Chand versus State of Himachal Pradesh, where it was held that if any circumstance is consistent with the innocence of the accused, then the benefit of doubt must be extended to the accused. In the present case, the prosecution has relied solely on circumstantial evidence, point to be noted, to convict Dr. Mehta and establish that he has administered a lethal dose to Mrs. Dhumal of morphine or tampered with the PCA pump. However, if the council may draw your kind attention towards the toxicology report, which is mentioned in para 9, page 3 of the Moot proposition. The toxicology report itself raises critical doubts as it is detected that there were traces of midazolam found, and midazolam was not a drug that was prescribed by Dr. Mehta. It is clearly mentioned in the proposition para 3, page para 9, page 3, that midazolam was not a drug that was prescribed by Dr. Mehta or was there in the treatment protocol. Therefore, this raises critical gaps in the chain of circumstances that are being relied upon by the prosecution to convict the council's client, that is Dr. Mehta.
Council, can I interrupt? You
Uh,
referred this case of the Supreme Court, Sarad Birdich and Sharda versus State of Maharashtra, where Supreme Court laid down five important principles on circumstantial evidence.
Indeed, Your
So
Lordship.
can you refer those five principles?
Indeed, Your Lordship, the five principles are that the circumstances must conclusively be proven and not left to conjuncture. They must solely align with the guilt of the accused. They should exclude all other reasonable explanation, and they should be definitive and compelling, and all alternative theories must be ruled out. Therefore, the chain of evidence must solely be complete and not leave any reasonable doubt, must solely point towards the guilt of the accused.
So chain is prepared.
In the present case, Your Lordships, if I may direct your kind attention towards Moot proposition para 24, the Sessions Court has relied upon convicting Dr. Mehta on the basis of forensic evidence which shows precise morphine overdose, as well as toxicology reports indicating medical expertise. However, the toxicology report also suggests that there's traces of midazolam found. This breaks the chain of circumstances. There are alternative theories of deaths that arise out of this. Moreover, the emphasis on medical administration of the dosage does not hold true in this case, because Dr. Mehta firstly had an airtight alibi. The council will get to it in the rest of the argument, and medical precision could have been done by Nurse Mathur as well, who was a trained medical nurse.
The presence of Dr. Mehta is required.
Indeed, Your Lordship, Dr. Mehta wasn't present at the time of the crime scene. He did not prescribe even midazolam, and prosecution has failed to prove how midazolam is being found over here. They have failed to look into that aspect as well. That gives out this alternate theory of death that the prosecution has failed to consider. Rather, they've just implicated Dr. Mehta purely based on circumstantial evidence, the chain of which is not being fulfilled.
Conviction can't be based on purely circumstantial evidence, but there are precedents which shows that conviction is possible only based on circumstantial evidence.
Indeed, Your Lordship. However, the chain of circumstances need to solely point towards the guilt of the accused. And if there's even an iota of reasonable doubt, which is there in the present case, then the benefit of doubt must be given to the accused.
Proceed.
Indeed, Your Lordship. Much obliged. The second leg of the argument refers to the inconsistent and uncorroborated witness testimonies. In the present case, the learned opposing counsels have relied upon Nurse Mathur's claims of manipulating medicine dosages. This contradicts her own cross-examination, and even Dr. Vinod Kapoor's testimony is unverified, further weakening the prosecution's narrative. If Your Lordships may find this in para 10 and then 20 and 21 of the Moot proposition. Firstly, Nurse Mathur did not claimed that the PCA pump was malfunctioning. However, later in para 20, she claimed that she was under Dr. Mehta's orders to tamper with the PCA pump. These are inconsistent testimonies that have been relied upon by the prosecution, and they show critical gaps in the chain of circumstances. The third leg of the argument rests on the airtight alibi that Dr. Mehta had. Dr. Mehta was attending a national medical ethics conference in Bangalore at the time of the alleged offense. He has extensive hotel records to prove the same, flight tickets, registration records, and eyewitnesses as well to prove and confirm his presence. Your Lordships may find this in para 17 and 18 of the Moot proposition. Therefore, the charge of murder and destruction of evidence does not hold true, as he wasn't even physically present at the scene, at the alleged crime scene. The final leg of this argument refers to the criminal conspiracy charge and how it is unsubstantiated. Now, under section 61(1) of the BNS, it requires clear evidence of meeting of minds for a criminal conspiracy charge to show the agreement between two or more people. In the present case, the prosecution has relied upon encrypted communications and financial transactions, which is mentioned in para 16, page 4 of the Moot proposition. But these are any normal routine medical communications that any medical professional would have with a pharmacist. Further, Dr. Mehta's petition for legal euthanasia, the fact that he took the trouble to go to the legal recourse rather than take into matters into his own hands, contradicts any alleged intent on his part. If Your Lordships are pleased with the arguments of the first issue, may the Council now address the second issue at hand.
Counsel, can you give us any authority where the court has any precedent where court has laid down that for criminal conspiracy you need prior meeting of mind in clear terms?
Indeed, Your Lordship, the case of Parveen versus State of Haryana 2021, it is a well-settled precedent that speculative or inconclusive evidence cannot prove a criminal conspiracy charge, and it is not safe to basically establish the guilt.
I asked a question, authority on prior meeting of mind.
Indeed, Your Lordship. The case also talks about how if there is any absence of meeting of minds between the conspirators, then speculative or inconclusive evidence
The
cannot
prior
point
meeting
to
of mind may be by conduct also. It may be implied also. So
Indeed, Your Lordship.
there is no express meeting is required for constituting criminal conspiracy.
Indeed, Your Lordship, the Council agrees. However, in the present case, it is clearly mentioned that his prior conduct was for petitioning for legal euthanasia. He does not have any prior meeting of minds with Nurse Mathur or Vinod Kapoor for that matter, who are the alleged co-conspirators in the present case. The prosecution has failed to establish that. They've only relied on routine communications, that are communications that are, it is clearly mentioned in the prop itself that these were routine communications. These are incomplete communications and were routine communications that any medical professional would have with nurses and the pharmaceutical company CEO. If Your Lordships are pleased with the first argument, may the Council now proceed towards the second issue at hand.
Yeah.
The second issue talks about whether a medical professional's act of assisting death constitute to murder under Section 101 of BNS. If the person has recorded their wish to die through a living will. In this issue, the Council would like to plead in a twofold manner. The first prong talks about the requisites of murder under Section 101 of BNS, which are not fulfilled over here. The requisites of murder are criminal intent, that is mens rea, and a direct act leading to the death, that is actus reus. In the present case, Dr. Mehta's intent, as previously established, purely medical and ethical. He neither sought nor caused death of Mrs. Dhumal. Furthermore, the presence of midazolam, that was a drug that was not prescribed by Dr. Mehta, raises reasonable doubt about the prosecution's claim. And in murder cases, the the burden of proof is always on the prosecution to prove beyond reasonable doubt, which they have failed to do so in the present case. Moving on to the patient autonomy and living will prong of the plea of the argument contention, it is contended that the right to die is protected under Article 21 of the Constitution, the right to die a dignified death, point to be noted. It was upheld in cases like Common Cause versus Union of India 2018, where Supreme Court recognized passive euthanasia and validity of living wills. In the present case, Mrs. Dumal had validated a living will but sought a dignified death. It is present in Prop Para 3, page 1. However, in the present case, she had sought a dignified death, and Dr. Mehta respected this autonomy and sought judicial approach. It is clearly mentioned in page 1 of the Moot proposition itself that he didn't take matter into his own hands, and he went to the High Court. He approached the High Court. The appeal was dismissed by the High Court. That is a case, that is a different case altogether. However, it clearly shows his bona fide intent to approach the legal authority rather than taking matter into his own hands. Therefore, in the light of lack of direct intent and evidence and strong legal considerations surrounding passive euthanasia in India, it is most humbly submitted that Dr. Mehta must be acquitted of all charges. If your lordships are pleased with the second issue, the council would like to ask the co-counsel to address issue
Counsel,
3 and 4.
you referred Common Cause versus Union of India. Can you briefly tell us that on what conditions the court allowed passive euthanasia?
The court, indeed, your lordship, in the case of Common Cause versus Union of India, the passive euthanasia bit was deliberated a lot. The court recognized the distinction between active and passive euthanasia and gave certain procedure or advance directives so that passive euthanasia must be fulfilled. And in the present case also, they have followed the particular elements of ADs that were laid out by the court. The court in the judgment said that the advance directives in the advance directive, the court required a medical board to be established. The medical board needs to examine the living will and the validity of the case. Then it will go to the High Court, and then High Court needs to on the grounds of the case and the facts of the case decide is the same. In the present case as well, it is clearly stated that Dr. Mehta approached the High Court following these advance directives that are also being presented on the screen for your kind reference.
Counsel, I have one question. First is with
Indeed, Your
issue one
Lordship.
also I wanted to ask you. You mentioned that Dr. Mehta was not present and he was not there at the time of the offense. So how do
Indeed.
you reconcile his contributions or his involvement with respect to digital communication? Could he not have remotely assisted all of these precision of...
Indeed, Your Lordship. Indeed, Your Lordship. However, the digital communications are incomplete and they are completely based on routine medical supplies. They are not talking about any criminal conspiracy elements. There is nothing to prove that criminal conspiracy charge. The routine communications are not hinting towards criminal conspiracy. He was the attending physician.
But the precision with which the morphine administration was done, and the fact that just by the mere possibility of the fact that midazolam was not prescribed at that time by Dr. Mehta, how do you justify, matlab, apart from just pointing out the inconsistencies, how do you justify that Dr. Mehta would not have, given this particular drug at that time later, remotely? Just by mere pointing out inconsistencies is not that I'm looking for. Can you identify any specific evidence?
Yes, indeed, Your Lordship. In the present case, as you mentioned, he could have given midazolam later. Midazolam, however, is not a drug that you will get on whim. It needs that prescription, and it is clearly mentioned it was not in the treatment protocol. The doctor cannot go beyond the treatment protocol. What the treatment protocol is laid out, the doctor has to stick to that treatment protocol. In the
Yes,
present case, the doctor.
sorry to interrupt, counsel. You just answered the question that midazolam cannot be given without prescription. That means that Dr. Mehta's hand was definitely required for getting midazolam.
The council begs to differ, Your Lordship. Since the doctor was approached only in the fall of 2023, the patient was suffering from ALS since a long time ago. She could have had any other attending physicians as well, and the burden of proof to prove beyond reasonable doubt rests on the learned prosecution. For the same, they have not proven the existence of midazolam. They have not proven that there was any prescription linked to Dr. Mehta for midazolam. If your lordships are pleased with these arguments, may the council now request the co-council to take up the issues 3 and 4.
Yes,
Yes,
please.
sir.
Yes.
Much obliged, your lordship.
Is the council properly audible and visible?
Yes.
Much obliged, Your Lordship. Greetings to the Honorable Bench. This is Speaker 2 of Team Code LMC 26, presenting the appellant side, which is Dr. Mehta. The Council will be addressing Issue 3 and Issue 4. The Council seeks permission to proceed with Issue 3.
Please.
Yes, please.
Much obliged, Your Lordship. Issue 3 states whether the conviction can be upheld in the light of chain of custody requirements as a standard of evidence under the Bharatiya Sakshi Adhinam 2022. It is humbly contended that Dr. Mehta's conviction cannot be upheld due to critical gaps in the chain of custody. The issue revolves the issue goes with a threefold argument. First, lack of examination of digital evidences. Second, contradictory toxicology report. And third, lack of examination of digital evidences. So before starting with the arguments, I would like to address what is chain of custody. Chain of
Council, can you
custody,
please hold your microphone a little closer to your mouth?
is it okay?
Yes.
Uh, Before addressing these arguments, I would like to address what is chain of custody. A chain of custody is a record of which has been handled and control evidences from its collection to the final presentation to the court. It revolves around various steps. First, collection and then examination of those evidences, then analyzing and then presentation of these evidences in the court. So the arguments revolve around all this four process. First, lack of examination of material evidences. To prove this argument, the council would like to draw your attention towards paragraph number 7 of the proposition, which refers, there is a rucked up Kashmiri carpet. There are various evidences which are found in the room. This includes rucked up Kashmiri carpet, a broken crystal paperweight, and a shattered reading glass. These evidences in the crime spot were not examined. Mrs. Dhumal, a ALS, third stage ALS patient, was unable to move. Then how can she break the items? Also, what is the work with these items if she can't able to move? Also, in the paragraph number 7 of the Moot proposition is contradicting with paragraph number 6 of the Moot proposition. Paragraph number 6 of the Moot proposition described at around 9 a.m. when Maya and Mr. Dhumal arrived, they found Mrs. Dhumal sitting still, looking towards the window. However, around 9:45, when the police detected, it was found that she was lay slumped over the mahogany decks. This refers the presence of any other party in the room, and examination of this evidences uh, would have presented any relevant information which would have helped to detect the actual suspect. According to Section 56 of Bharatiya Sakshi Adhinam, mandates that documents may be proved either by primary or secondary evidences. This refers material evidences should be considered as primary evidence. However, no forensic analysis was conducted of these evidences. According to Section 39, Clause 1 of Bharatiya Sakshi Adhinam, states that court cannot form an opinion without expert examination of evidences. Further highlights the break in the chain of custody due to non-examination of evidences. Secondly, contradictory toxicology report. To prove this argument, the council would like to draw your attention towards paragraph number 9 of page 3 of the Moot proposition, which is presented by the researcher. It states that toxicology report confirm a lethal overdose matching empty vial found in the study's Westparcel, while it noted a precise dose of morphine suggests medical experts guidance. It becomes inconsistent in the exact next line, which refers midazolam, a drug that was not prescribed. Your lordship, isn't the toxicology report contradicting in itself because both the drugs requires medical practitioners' recommendation for purchase. Additionally, Dr. Mehta was out of the city at that point, confirmed by two eyewitnesses, Dr. Shah and Mr. Menon, and the flight tickets as well as the hotel reservation. This confirmed evidence does not align with the chain of custody due to inconsistent analysis process, further weakening the prosecution's case. Thirdly, lack of examination of digital evidences. To prove this argument, Your Honor, the counsel would like to draw your attention towards paragraph 8, page number 3 of the Moot proposition, which refers that there was a 15 minutes video dated April 12, 2024, captures Mrs. Dhumal's deteriorating condition, her frustration with the High Court's ruling, and her clear statement absolving everyone of responsibility for her death. Under Section 2E2 of the Bharatiya Sakshi Adhinam, this refers the qualifications of documentary evidence, and according to Section 57 of Bharatiya Sakshi Adhinam, it recognizes electronic evidence as a primary evidence. However, there is no expert examination of this videography, which refers there is a gap in the chain of custody. It is humbly submitted that Dr. Mehta's conviction cannot be upheld due to this significant evidentiary gap. The counsel seeks permission to proceed with issue 4.
Yes, please.
Much obliged, Your Lordship. Issue 4 states whether Dr. Mehta and Nurse Mathur should be held liable for criminal conspiracy instead of murder. It is humbly contended that Dr. Mehta is neither liable for criminal conspiracy with Nurse Mathur nor liable for murder. The issue goes in a threefold manner. First, failure to establish criminal conspiracy. Second, inconsistent testimonies. And third, lack of evidence against Dr. Mehta. So the issue proceeds with the first argument, failure to establish criminal conspiracy. To prove this argument, the counsel would like to draw your attention towards paragraph number 16 of the Moot proposition, which states digital forensic analysis reveal message between Dr. Mehta, Nurse Mathur, and Mr. Kapoor, which only discuss routine supply and standard commission for prescribing medication. However, there is no illegal transaction or agreement between them. According to Section 61 of Bharatiya Nagarik Bharatiya Nyaya Sanhita, which states that a criminal conspiracy requires an agreement between at least two persons to commit an offense. Also, uh, an independent audit, which is Roy and Associates, have found there is no mismanagement of financial transactions or illicit transactions of Doctors Mehta's.
How financial transaction is important here?
However, in the much obliged, Your Lordship, for the question. Um, However, in the paragraph 16, it has been stated that there is only the routine supply of medications. According to Section 61, it has been defined there should be an agreement between the persons. If there is any kind of agreement would have occurred, or if there is any kind of
That agreement may be expressed, that may be implied also.
Indeed, Your Lordship. Indeed, Your Lordship. But however, in the present case, it has been found there is no illegal transactions of money, or there is no
No, money. How that's why I asked this question. How money is relevant? He's a crusader. Dr. Mehta is a crusader of human dignity, and he claims that right to die should also be included in right to life. So, person
in,
should get a dignified death, and he
in,
has been trying in number of cases.
indeed, Your
So
Lordship. Indeed,
there appears to be a motive. Hmm?
indeed, Your Lordship. However, if there is any kind of motive from the side of Dr. Mehta, then there should be the reference of the motive. But there is no reference in the communication.
No,
Messaging.
reference that he approached High Court and he claimed that the accused, should be given euthanasia, allowed for euthanasia, shows the motive.
Indeed, Your Lordship. But however, in the present case, he was not even present in that position.
Presence is not required. The presence of the accused person is not required on the site. Hmm?
Your Lordship, but if there is any kind of reference of it, it would have been prevalent in the uh, in the in the communication itself, in
No,
the messaging
the
communication.
proposition says that there is a communication between Dr. Mehta, the nurse, and the Mr. Kapoor, the pharmacist. Eh? You will not see the doctor is not an ordinary layperson that he will write in the WhatsApp text or in the message that go and give this overdose of this medicine or this morphine or midazolam, whatever. Hmm. So indication may be sufficient. This prima facie appears that they are in communication. They are talking to each other. Hmm.
Indeed, Your Lordship, but however, the council seeks to begs to differ in this case, and if we think uh, of the interest of Dr. Mehta, there is no bona fide interest of him. So this can't be categorized as he was having the interest of attempting the criminal conspiracy with Nurse Mathur. However, in certain cases, it has been described that Nurse Mathur is having some personal grievance against Dr. Mehta. So, how it would have been the implication of criminal conspiracy between Nurse Mathur and Mrs. And Dr. Mehta?
Counsel, the doctor has been described as a very fierce doctor who, basically would do anything to give relief to the patient. And if the doctor would not have any kind of motive or any kind of bona fide intention to cure her, he would have not filed the writ petition in the first place. So, how are you denying the fact that there is no motive and that the doctor did not want the Dr. Mrs. Dhumal to get relief?
Indeed, Your Lordship. Um, so in the present case, uh, there are certain. So the present case is whole revolves around criminal conspiracy or not. So if there is any kind of reference of criminal conspiracy, then Nurse Mathur would have agreed on it. So there is no
But
agreed.
counsel, where would Nurse Mathur, in how do you differentiate between regular communication to any kind of potential conspiracy communications? How will you differentiate? Nobody, as sir also said, nobody is going to directly write down things because they are also smart enough. They are not going to say it directly, right? So, how do you have any specific, apart from just pointing out that this is an inconsistency, do you have any specific thing to mention that this was very different from your regular communication?
Indeed, Your Ladyship. So in the present case, if we see that there is a reference of midazolam as well. If we think of midazolam, there is a regular communication of medical supplies. If there is the reference of midazolam which was found, then in the communication itself, it would have been prevalent that there was a recommendation of midazolam. It was not found. So this can be considered as there is no illicit communication between Dr. Mehta and Nurse Mathur or
Counsel,
Mr. Vinod Kapoor.
Counsel, don't you see the alibi is meticulously designed? There had already been a prior meeting of mind that you do this, I'm going there. So on one hand, Dr. Mehta is having a watertight, complete alibi. On the other hand, he is already meeting up mind with other partners in that crime. What do you say on that? Don't you see the circumstances clearly indicate towards the same?
Indeed, Your Lordship. However, the council begs to differ on this case.
Yes, yes,
In
please.
the Indeed, Your Lordship. In the present case, if we think of the whole situation, uh, it has been found that there was no agreement first, and secondly, the alibis which were present. The alibis refers that throughout the week he was not present. Throughout the week he was not present. So this can be considered as the thing.
Counsel in these kind of cases, this is a routine practice. This is the practice. They will plan, and then they will uh, go to somewhere so that they can take the plea of alibi. What my learned brother suggested. Hmm.
Indeed, Your Lordship. So, if there is also the testimonies which Nurse Mathur have given, it has been found that it is through the cross examination. She was not even, she was having a certain amount of personal grievance towards Dr. Mehta. So, if there is a reference of this alibi present and there is a meeting of mind of the people, then it would have been prevalent that. Then it would have been prevalent that that the
And
ali-
mood proposition somewhere also suggests that this has happened, and this kind of thing has happened earlier also. Whenever this kind of cases have come before Dr. Mehta, and we find the increase in the supply of these kind of drugs. Uh,
indeed, indeed, your lordship.
hmm.
However, I
So
would
this also proves that Dr. Mehta somewhere has been part of this kind of practice. Hmm.
indeed, your lordship. However, the council would beg to differ in the whole case. If we see the the statements which are given by the patient's family, it has been found that they have themselves confirmed that there is no involvement of Dr. Mehta. So it can be expected that there is no involvement of Dr. Mehta because the patient's family itself has stated it. How can the patient's family would have a criminal conspiracy with Dr. Mehta to commit their family members into a death?
No, family member, they also wanted passive euthanasia. Uh, so there may be a prior meeting of mind. Because end result, both wanted same end result.
Indeed, Your Lordship. But however, if we refer to the to the cases, it has been found that it was an accident. There were certain there were it was being referred in the moot proposition 12 and 13. Also in 11, 12, 13, it has been found that the patient who were there, um, she has fell down from accidentally from the stairs. And also, in another case, it has been found that uh, that he generally used to ignore the instructions of the medication. So these cases would have been prevalent.
Okay, all right.
Indeed, Your Lordship. Secondly, inconsistent testimonies. According to paragraph 20 and 21, which refers inconsistent testimonies of Nurse Kapoor and Vinod Kapoor. According to paragraph 20, the first line claims that there was a that she has done all these things uh, regarding the falsified uh, regarding a falsified record, manipulation, medication dose under the instruction of Dr. Mehta. However, in the exact next line, it was found that Nurse Mathur's testimony is conflicting with her cross examination, particularly regarding her involvement in record tampering and a lying meeting with Mr. Kapoor. Certain evidences also indicate she has a personal grievance against Dr. Mehta. Now, if there was a personal grievance from Nurse Mathur's side, how can it refers to the involvement of criminal conspiracy? Similarly, according to paragraph 20 of the proposition, refers Mr. Kapoor's testimonies lacked inconsistent verification and appear strategically designed to deflect attention from his own legal trouble. Thirdly, lack of exact evidences against Dr. Mehta. Under Section 49 of Bharatiya Sakshi Adhinam states that an accused bad character is irrelevant unless evidence of good character is present, making it relevant. Dr. Mehta's good character is well documented through the alibis which was presented by Dr. Shah and Mr. Menon, and also the flight tickets and hotel reservation. Furthermore, his long-standing reputation as a for patients' rights, his published work on medical ethics, and affidavits from the esteemed professional attesting to his integrity reaffirmed his good character. If he had the intention to harm Mrs. Dhumal, he would not have filed the passive euthanasia petition for the passive euthanasia. Thus, it is no substantive evidence linking him either criminal conspiracy or murder. It is humbly submitted that Dr. Mehta is neither liable for criminal conspiracy with Nurse Mathur nor liable for murder. The council seeks
Not liable for murder, but can he be held responsible for culpable homicide, not amounting to murder?
um, indeed, Your Lordship, but however, the council seeks to begs to differ in the case that there is no involvement as there is no presence of Dr. Mehta, and this refers that he was not having any intention to kill Mrs. Dhumal. The council seeks permission to proceed with the prayer.
Council intention to alleviate the pain by killing is not murder.
There are certain medications which are prescribed by Dr. Mehta. So, however, this can also alleviate the pain. But if there is an intention to kill or to elevate, then he would not have filed the petition of for the euthanasia.
So he did file the petition, but the petition got rejected. Hence, he found this particular way. And you said that the past cases of Dr. Mehta's patients are irrelevant because of different circumstances. Now, can this is a pattern? This is pattern of suspicious outcome. So can it be entirely dismissed?
Indeed, Your Ladyship. However, if we refer to the paragraph 8 of the page number 3 of the Moot proposition, it has been found that in the 15-minute video, Mrs. Dhuma has herself absolved everyone of the responsibility for her death. If so, this can
Is
also
it
be.
relevant? Is it relevant, counsel? Huh?
Exactly. What is, I can also say a lot of things and then write
Mhm.
it in a piece of paper. Is it going to be my sole? Can I use it as a sole evidence? Such a strong circumstantial evidence is there, okay? Just by merely pointing out these inconsistencies is enough for you to conclude that he is not liable for murder?
Indeed, Your Ladyship. However, the council seeks to beg for the beg for differ in the present case. It has been found that it was not a mere recording. It was the recording which was where she was stating all these facts. So, as she was stating all these facts, this would have been prevalent that she has the intention to end her own life. So this can be also be considered as a suicide as well as her intention to kill herself.
So, but assisting to suicide is murder, right? If I assist someone who wants to commit suicide, then what am I doing?
He was not assisting suicide. According to him, it has been a part of his job to refer that uh, to reduce the pain of the of the of his patient, and this can be considered as part of his job, so he can't be held liable for murder or criminal conspiracy.
And how do you justify the intention, the mens rea that is required for murder? All this advocacy, this entire mysterious death past cases of terminally ill patients, and after rejection of advocacy, the for euthanasia, how do you justify the mens rea of Dr. Mehta?
um the council would like to the council would like to keep draw your attention towards paragraph number 11, 12, and 13, refers that which refers that the patient who died in the sense of euthanasia were totally accidental, so it can't be considered, and this has like if we think of a person who fell down from the stairs, or a person who has not taken the medication, how can this interrelate with the whole thing? If a person fell down from a stairs, this there is no reference of committing criminal conspiracy, so there is no intention of him.
Council, there is another offense in Bharatiya Nyaya Sanhita called abatement. And abatement can be done in three ways. One is abatement by instigation, abatement by way of criminal conspiracy, and abatement by intentional aiding. Hmm.
Indeed, indeed, your lordship.
So, Dr. Mehta may be held responsible under abatement by way of conspiracy. Hmm.
Um, Indeed, your lordship. However, the council begs to differ in the whole case. It has been presented that uh, that there is no intention of him, as it's a part of job, and euthanasia is legal in certain cases. Um, in certain cases, so this won't be considered as abetment to suicide. The council seeks permission to proceed with the
Is
prayer.
it part of his job, Dr. Mehta's job, that he should approach court and he should request the court that person should be given passive euthanasia?
For
Is it
an
part of medical ethics or his duties as a medical practitioner?
um Yes, it is a part of his work. However, in the present case, if we I would try to draw your attention
What
to
is the oath doctors take? Uh, the Hippocratic oath, which we popularly.
um, in the Hippocratic oath, it has been defined that it is the part of his job to
To
reduce the
save the
pain,
life.
to save the life.
Yes.
Indeed, your lordship.
Hmm.
However, I would try to.
Any authority, any reference, any authority, any citation where you can prove that it is part of doctor's duty to help patients to get passive euthanasia so that they can get a dignified death. Any writing, any paper, any case law, anything.
Um, as of now, the council is not aware of any case law.
Then why Dr. Mehta was so particular about passive euthanasia that he will advocate and he will approach court and he will try all his efforts to do and execute that person gets passive euthanasia.
Indeed, your lordship. If we, I would like to draw your attention towards paragraph 3 of the Moot proposition, which describes that it was through the supervision of the of Mrs. Dhumal, as well as Mr. Dhumal as well. Because of shortage of time, the council would like to proceed with the prayer.
Okay, all right.
Much obliged, Your Lordship. In the light of the issue raised, argument advanced, legal authority cited, may this honorable court be pleased to: number one, set aside the conviction rendered by the Shimla Session Court. Number two, declare and uphold that Dr. Mehta's action were within the legal and ethical framework of palliative care and do not constitute an offense under the prevailing law. Number three, exonerate the appellant from all the charges of criminal conspiracy and murder, and or pass any other order deemed fit in the interest of justice, equity, and good conscience, all of which is most humbly and respectfully submitted.
Thank you so much.
Thank you.
So the
With
prosecutor
the
defense.
with the permission of the honorable bench, the council seeks permission to proceed.
Yeah, please go ahead.
A very good morning to the honorable bench. The council seeks permission to address the honorable bench as your lordships and your ladyship. Much obliged. It is submitted that Speaker 1 and Speaker 2, along with our researcher, appear here on behalf of the respondents. We'll be taking 14 minutes for issue 1 and 2, that would be taken by Speaker 1, and 13 minutes would be taken by Speaker 2, and 3 minutes would be reserved for rebuttal. If your lordships and your ladyship is satisfied with the facts of the case and statement of jurisdiction, the council would seek permission to proceed with the issues at hand.
Yes.
Much obliged, your lordships. It is submitted, the first issue being whether the trial court erred in the conviction of Dr. Mehta for murder, destruction of evidence, and criminal conspiracy. It is submitted before the Honorable Court that the conviction of Dr. Mehta on these grounds is based on careful evaluation of forensic evidences, witness testimonies, and circumstantial facts that, when considered in their entirety, establishes his guilt beyond a reasonable doubt. The reliance would be put, the reliance would be put on circumstantial evidences, but not solely on that, your lordships. The reliance would be put in the corroborating and substantiating factual investigative evidences as well, and apart from that, forensic findings as well. It is submitted that we'll be establishing beyond a reasonable doubt the basic components of alleged crimes, that are intention, prior meeting of mind, and prior agreement, have been fulfilled and proved beyond a reasonable doubt. To proceed, your lordships, we have the council would seek permission to present for the perusal of the honorable court the prop and memorial.
Yes.
Much obliged. Is it visible, your lordships?
Yes.
Yes, we can see.
To begin, your lordships, the reliance has been put on the principles that have been upheld in the cases of Udaipal Singh versus State of UP, Sukhram versus State of Maharashtra, as well as the case of Gija Gandha Somaiya versus State of Karnataka, where the emphasis has been put on the specific importance of circumstantial evidence, and we need to establish if the evidence shows that the accused having a strong enough motive, had the opportunity of committing the crime, and the established circumstances on the record considered along with the explanation, if any, he may in that event safely be held guilty on such circumstantial evidence. And we'll be establishing that only. Your lordship, to explain further the intention, we may refer to the very first paragraph that specifically talks about, in the first paragraph of Moot preposition, it talks about Dr. Aditya Mehta being a fierce crusader for his patient's right. It is pertinent to note that the Moot preposition is the sole authority right now the parties refer to for understanding of the whole world and characters and their nature. While referring to the specific term fears, we may refer to the very specific principle of interpretation of statutes. That is the literal rule or grammatical rule of interpretation, where a term is interpreted through its common and general use. When we see the term fears, we may refer to its dictionary meaning. It refers to various different meanings that are violently hostile or aggressive in temperament, given to fighting or killing, marked by unrestrained zeal or vehemence, furiously active or determined. All of these words, all of these common terminologies indicate only one thing, that Dr. Mehta is having a character and it's in his nature that he would not sit ideally. He is an unrestrained person who would do anything for the fulfillment and upholdment of his patient's right. The same, your lordship, can also be observed in the Moot proposition, para number 2.
Counsel, what is wrong in advocating patients' rights of euthanasia?
Lordships, it
As
is
a doctor, as a medical practitioner, he has all rights
indeed
to
your
write
lordship.
to write in journals, to do research, and to advocate for patients' right to live with human dignity and die with human dignity.
Indeed, your lordship, we
And
agree with the
it is
same.
not only Dr. Mehta. There is a lot of movement which is going on, which is advocating towards euthanasia. There are
Indeed, your
countries
lordship.
which has adopted even active euthanasia. That in some cases the court can allow active euthanasia. They have made law. So what is wrong in advocating this kind of? You can't attach a criminal intent with this.
Indeed, your lordship. If given the opportunity to answer the same, we submit to this specific point that this passive euthanasia as advocating is indeed lawful, and we submit to it. But your lordship, the intention becomes very clear when we see in paragraph 2 of the moot preposition itself. Miss Kalpana Dhummal, here specifically highlighted, your lordship, Miss Kalpana Dhummal and her husband approached Dr. Mehta seeking only passive euthanasia. Now, it is pertinent to note, Your Lordship, that in para 3 itself, Dr. Mehta filed a writ petition before this honorable bench only, before this honorable court only, in January 2023. But indeed, it is important to note that he was seeking the administration of medically supervised lethal doses of morphine, which does not fall into the ambit of passive euthanasia.
So,
The
counsel,
difference between,
what would have fallen under passive euthanasia according to you in this case?
indeed, Your Lordship, passive euthanasia refers to withdrawing or withholding the life-preserving machineries,
But there was no,
where
that's what I'm saying, there was no support system that Mrs. Dhumal required anyway. So how would
that
the
is
passive euthanasia would be applicable here?
throughout the argument, Your Ladyship, will be establishing that Mrs. Kalpana Dhumal was not even eligible for any kind of euthanasia, and that is why her euthanasia request was also denied. To proceed further, Your Ladyship, in the case of Aruna Shanbag versus Union of India, it has been upheld that only passive euthanasia is legal and would fall under the ambit of Article 21, whereas active euthanasia is a crime all over the world. The specific fact that Dr. Mehta sought administration of medically supervised lethal doses of morphine, which would fall under the ambit of active euthanasia, even he was an expert and a professional having all of these expertise and having a long record in the specific field. He still, just to act upon his personal belief, because he knew that he is not eligible for even passive euthanasia. We need to consider para 15, Your Lordships. Para 15 of the Moot preposition tells us about the condition of Mrs. Dhammal. It states that she was in an almost vegetative state. Now, if we go back to, how do I, sorry, I'm unable to switch the memorial. If we go back to the specific page number 19 of the Moot Memorial, Your Lordships, we may refer to the case law Common Cause versus Union of India, where though two different conditions are mandated, which are the person should be in permanent vegetative state as well as or brain dead. Miss Kalpana Dhummal was neither brain dead nor in a persistent or permanent vegetative state. She was in an almost vegetative state. She had not reached that specific eligibility criteria yet. And the same reasoning was also given by this honorable court only in in the paragraph fourth, where the court deliberated on the distinction between both the euthanasias and set aside the request on the basis that Dr. Dhummal sought active euthanasia. Your Lordships, the petition from the beginning itself was against the legal grounds of the prevailing laws of the country. Now, after this dismissal and the disappointment of both Ms. Dhummal as well as Mr. Mehta, this led to Dr. Mehta orchestrating a master plan, which required the inclusion of a supplier as well as an insider. The supplier being Mr. Kapoor, owner of Lifeline Pharmaceutical, which has also been referred in paragraph 14. Paragraph 14, there is a reference to Mr. Kapoor. This Mr. Kapoor, Mr. Vinod Kapoor, the owner of Lifeline Pharmaceuticals. Apart from this, Nurse Mathur, who was a close insider, who has been with Judge since her childhood, who used to cry watching her in this condition and had the sole access to the PCA pump, as also mentioned in para 10 and para 15 of the Moot preposition. This argument would be corroborated with the forensic findings as well as the testimonies of the Mr. Kapoor as well as Nurse Mathur. We may refer to para 9 specifically, Your Lordships. It is mentioned the initial toxicology report suggested morphine overdose. The concentration of morphine was precise, as if administered by a medical expert, and just enough to kill a person. More troublingly,
Counsel, just one question. How can just the access to morphine or the perfect amount of morphine establish intent? I mean, can it not come from anywhere? The nurse was trained. Given that this case relies on circumstantial evidence, how do you ensure that no other explanation exists for this overdose?
Your, Your Lordship, it is humbly submitted that the intention does not arise from here. These are just corroborating the intentions. The intentions arrived from the specific fact that the petition was dismissed and he was of such a nature he would do anything to help his patient. And
So,
he, to
counsel,
begin
under
with,
Council, you have to prepare a chain of events as
indeed,
laid down in Sharad Birdich and Sarda case.
indeed, your lordship,
Circumstantial evidence, you have to prepare a chain.
indeed, your lordship.
So prepare a chain of events without
And
without any leakage, without any breakage. Hmm.
lordship, we have already
We have
established
we
the
have in
foundation.
we have written in the moot proposition that there was evidence that just before this incident in the computer of the uh, on this deceased, it was found that there was a search about passive euthanasia. There was a search about the overdose, morphine overdose, and midazolam. So this also indicates that the deceased was also, she was not an ordinary layman. She was a high court judge. So she
It is
she can
pertinent.
also administer, she can also procure, she can also administer.
It is pertinent to note, your lordships, that she was not capable of administering these things. He was in an almost vegetative stage. He would require an assistant. And
But
Nurse
you you
Mathur,
you you
she had
you
the
sometime back you said that she was not in a vegetative state.
it does not matter. She was not in a permanent vegetative state. Even if she was in almost vegetative state, she would
You are
not be able to
contradicting
inject,
yourself, counsel.
your lordship, she would not be able to inject herself with with a specific medication that was not with her to begin with. It was brought by a third party with
Counsel,
an
can you
expertise with
rule out the possibility where judge actually instructs somebody to inject a specified amount of the lethal dose in her body? Can you rule out that possibility?
And
indeed, your lordship.
Dr. Mehta was not there, so he would not search on the computer of the deceased. Eh?
It is pertinent to note, your lordship, that the search was not specifically related to euthanasia. It was related to PCA pumps and morphine. That's it. Not
Yes.
its overdose, not lethal overdose, not any kind of euthanasia. It was a mere search weeks, the weeks before her death, not just a day or two before her death. This has nothing to do with the possibility of her. Why would she stage her own death? She was a person who had an utmost regards for justice. She, throughout her career, was the person who delivered justice. Even in her last video, she relinquished everyone of the obligation of her death, not her murder, of her legal and her moral obligation of all the people who caused her misery and death. He was disappointed with justice and all the people who
He was
granted
disappointed with the High Court
indeed.
judgment rejecting
But
passive euthanasia. So this also, I think, goes in the favor of Dr. Mehta.
Your
Not
lordship,
not
that does not change the fact that that video, specific video, does not implicate. She was a retired justice. She knew that this mere video would not remove anyone's obligation of a legal murder. She was a retired justice. She was creating this video specifically for single reason, that even though I am disappointed with the justice system, I remove and relinquish everyone of their moral responsibility of causing me misery. This was the sole purpose. The research does not indicate that she herself did any kind of thing or any kind of
No,
causing.
I accept your argument that some other person would have helped
Indeed,
deceased to get the overdose of morphine or some other drug, but it may
with your
not be
permission,
Dr.
Lord,
Mehta because
with
he
your
was not there, he was not present, and there is a proof that he
with
was
your
not.
permission,
Hmm.
Also,
with your
counsel,
permission.
Nurse Mathur and Mr. Kapoor also had access to records independently. So, how are you
Indeed,
ruling out them acting alone without Dr. Mehta's contribution, without his presence?
we are, if given the chance, we'll be establishing in our argument only that the testimonies are also corroborated with the findings that implicate direct and indirect implication of Dr. Mehta as well, if given the opportunity, if I continue with my argument.
Yes, please,
Much
please.
obliged. Much obliged. It is submitted that in para 19, there is a reference given to the precise administration of doses as if it was administered by an expert. The same is corroborated by the testimony of Nurse Mathur. If we see para 21 of the moot proposition, it is stated that he did indeed uh, she did indeed manipulated the medication doses and falsified medical records, but under the directives of Dr. Mehta, the said expert, whose expertise was essential as referred in para 9. This was first implication, your lordships. This moving to the second implication. When we see similarly, Mr. Kapoor turned a whistleblower against Dr. Mehta. He was facing imminent legal repercussions and the potential collapse of his pharmaceutical enterprises, and he provided an incriminating testimony, which we have not relied solely upon. His testimony, supported with the findings of police in para 17, the same was corroborating when the investigation discovered a sudden hike in orders for specific medications just before each death. It is pertinent to note that there were prior deaths as well, having similar occurrences. These parties died, which died earlier as well. These parties approached Dr. Mehta. They were terminally ill. They filed for petition, which got denied in all of these cases. Then there were sudden hikes in specific medications. It is pertinent to note that the argument is also supported by Section 13 of BSA, which states facts bearing on question whether act was accidental or intentional. The fact that such act formed part of a series of similar occurrences, in each of which the person doing the act was considered, is relevant and cannot be ruled out as a mere accident. It was rather a facet of accident. It was a planned, and it also indicates on the allegation that there was an unauthorized euthanasia network going on. Moving further, moving further, this agreement and prior meeting of mind is also established in para 14, where the parties visited had late night visits. Apart from this, para 16, where all the three had conversation on a messaging app. This is further elaborated in the specific allegation destruction of evidence as mentioned in section 238. It is submitted that para 14 talks about clandestine visits between Mr. Kapoor and Reena Mathur. The CCTV does not directly implicate Dr. Mehta, but the presence of Mr. Kapoor, whose company was already under investigation for irregularities, and its connection with the sudden hikes by Dr. Mehta's clinic in procurement of specific drugs, as mentioned in para 17, strongly indicates a deliberate effort to obscure illicit activities. It becomes evident that Dr. Mehta was not merely a passive observer, rather, he had an active participated role to play. It is pertinent to note that, as per section 61, it is not necessary for Dr. Mehta to be physically present there. He can indirectly guide or direct the other parties to act upon all of these things. To conclude, it is
Council,
submitted.
is it not possible that after rejection of the plea from the High Court of Himachal Pradesh, this may be one possibility. That Dr. Mehta, because he is a crusader of patients' rights, and he believes that person should be given passive euthanasia if required, and if he has a living bill. If it is rejected, then there is a possibility that patient will try to execute that himself or herself, and that will
Your
be done
Lordship,
only through taking medicine from outside.
Your Lordship, this possibility is completely ruled out by
There
the
is no there is only proof in the proposition that they were in communication, it was only routine communication. There is nothing against that there was some kind of criminal intent or some kind of conspiracy that you bring that dose
Your
or you
Lordship.
administer that.
When we corroborate these communications, these meetings with the testimonies, with the forensic findings, and when we consider all of them together in their entirety, as well as we see the fact that Miss Kalpana Tumal reached out to Dr. Mehta seeking passive euthanasia, whereas Dr. Mehta filed for active euthanasia. These are again contradictory things. This completely overrules the existence of any third party or self administration by Mrs. Kalpana Dhumal. Dr. Mehta was acting on his personal belief rather than any kind of medical ethical conduct. He just wanted to end her misery, not even considering that she was not eligible.
Mr. Counsel, can you educate me the difference between active euthanasia and passive euthanasia? The
Indeed, Your
thing
Lordship.
hotline. Can you educate me on that?
Active euthanasia refers to administration of lethal doses of any specific drug. whereas passive euthanasia refers to withdrawing or withholding life-providing machinery. In this case, Mrs. Kalpana Dhumal reached out in para 2 seeking passive euthanasia, but in paragraph 3 it is stated clearly that Dr. Mehta in his petition sought legal administration of lethal doses seeking active euthanasia, and for this only the plea was dismissed.
Fine. So can you help me to understand for my education that, to my understanding, if there is an external element, human intervention in taking away the life, that is some kind of euthanasia. So passive as well as active. Can you just differentiate between the thin line between these two? Because to my understanding, active euthanasia also requires some kind of human intervention. Passive euthanasia also requires some kind of intervention. And when it is clear, when it is very clear that the lady can't survive, the High Court judge is not likely to survive with full human dignity, so it is okay to end her life, and she goes to High Court. High Court says, no, I'm not giving you the permission. She, being a person who has upheld justice in her court throughout her active life, immediately, I'm just giving an alternative theory, comes to a conclusion, fine, if that is not happening, I'm going to give justice to myself. Can you rule out that possibility? Because her mind
Yes,
is
your lordship.
completely intact. The Moot proposition says that she may be in vegetative state, but as far as her mental functions are concerned, that is completely fine. She is able to understand the consequences of her acts. So can you enlighten that you have no second alternative theory in this? Because this is a case which is based upon the chain of circumstantial evidence. This is a case, and another thing, this is a criminal case. There is no question of preponderance of probabilities. If there
Yes.
is an alternative, if there is any second theory that is permissible, howsoever weak that may be, shall be ruled in favor of the accused. So are you in a position to rule out that alternative theory, or even a slightest element of the doubt in this case about the guilt of Dr. Mehta? Would you?
Your lordships, it is submitted that the alternative theory your lordship suggests has been ruled out in the para 7 itself, where it is stated that there was when the authorities and Mr. Dhumal entered the room, there was a story of disruption. There was struggle. There were things broken, laying down on the ground. There was her glasses were lay broken. There
Yes.
was a story of struggle. There was no. Why would a justice?
No, no,
Why
no, no.
would a former justice?
I'm intervening at this juncture, and I would
Indeed.
like to read out, because you are the prosecution and you are before a court where you have to actually establish that prosecution is right, not only on facts but also on law. And but the facts are more important. Fine. So I would
Indeed.
like to read it. The police arrived at 9:45 a.m. to find out a scene that would be an investigation nightmare for them for months to come. Mrs. Kalpana Dhumal is still elegant in her powder blue nightgown, lace slumped over her antique mahogany desk. Her silver stitched hair and usually impeccably styled fell across her face. The patient control uh, analgesia pump connected to her left arm. A laptop remained open beside her. Its screen is still showing a paused video recording. The room told a story of disruption. A Kashmiri carpet, quote unquote, racked up at the corners, a broken crystal paperweight under the window, and her reading glasses. The expensive titanium frame she would imported from North Korea, quote unquote. So now, any import from North Korea is banned. North Korea is completely isolated. So whether the prosecution, the police has done any investigation from that angle, how a product from North
Lordship,
Korea was available at the scene of crime?
Lordship, the specific argument is relating to the story of disruption here. The imported product from North Korea being present there is a completely different case and have been dealt, but the move proposition is silent about that and does not refer or consider is to be considered in the specific case.
No, Moot says that it is from North Korea.
Your Lordship, but
I'm
no
just
question
asking.
of law
I'm
has
just
been raised
asking because
regards
you
to
are the
this.
prosecution. Have you thought about that?
The chain of custody and standard of evidence has been followed and would be dealt by my co-counsel, and the same would be answered by
And
him in the following
counsel,
issues.
you also referred that Dr. Mehta applied for active euthanasia despite
In,
this fact that the deceased requested for passive euthanasia.
indeed, Your
I
Lordship.
don't agree with this proposition. Where can you refer moot proposition that
Indeed.
Mrs.
When,
Dhumal requested for passive euthanasia and Dr. Mehta applied
indeed, Your
for
Lordship.
active euthanasia because the writ petition which was filed on behalf of Dr. Dhumul, Mrs. Dhumul. Yeah. So
Indeed, Your
without her
Lordship.
permission, without her concurrence, Dr. Mehta could not file a writ petition in the High Court, and she was also disappointed with the decision of the High Court. It means that she was in concurrence with the writ petition which was filed by the Dr. Mehta. So
Your
can you
Lordship,
refer from
it would be,
proposition the line
yes,
where you draw this conclusion that it was for passive euthanasia?
indeed, Your Lordship. The paragraph 2 of the moot proposition itself and the last line. She and her husband, a retired philosophy professor known for his scholarly works on medical ethics, supported her decision to seek release through passive euthanasia. And in third paragraph, it is stated Dr. Mehta filed writ petition
Hmm.
seeking the administration of medically supervised lethal doses of morphine. Both are contradictory to each other.
No, so
Your Lordship.
that writ petition you are claiming was filed going against her will or what she wanted or
Lordship,
without
it
her
is
consent?
submitted that
Hmm.
it is a judicially noticeable fact that the moot proposition itself states these things.
No, no. From moot proposition, you are drawing this inference
Indeed.
that this writ petition was filed by Dr. Mehta going against the will of the deceased, Mrs. Mathur. She wanted passive euthanasia, and Dr. Mehta filed a writ petition seeking active euthanasia.
Your lordships, this disagreement is absent in the moot proposition. But again, all the circumstances indicate to this inference only that both of these active euthanasia and passive euthanasias were sought by different parties. Mrs. Dhummal sought only passive euthanasia, whereas Dr. Mehta filed for active euthanasia.
But
Apart from this,
why was she disappointed with High Court decision, which rejected the plea?
Your Lordship, it is pertinent to note that even if she was aware of her condition and not being eligible for passive euthanasia, she still wanted to die. She had a will to die. It is easy to have a presumptive reasoning that she supported the argument. This disagreement is not present. She might have supported the argument, but then again, that does not empower anyone to come out of the blue and murder her. She wanted to follow the due process of law. She went with the petition. It got dismissed. She was dissatisfied. She created a video showing her dissatisfaction that never showed any kind of obligation being removed of her murder. She was a former judge who knew that this does not remove anyone's obligation from legal murder. This was just moral obligation of causing her misery, and that she was relinquishing people of that only.
And filing a writ petition and expressly referring that what Dr. Mehta wanted, also maybe one possibility that he was open to all kinds of ideas because he was a active crusader and advocate of euthanasia. So he did not hide anything. So he wanted the High Court of Himachal Pradesh that this should be allowed. Hmm.
Lordships, the prosecution have established that Dr. Mehta sought active euthanasia, which is against the legal holding and understanding of euthanasia in India. But when we see that the reasoning your lordships are stating has not been provided by the appellants or established
Okay, proceed. There's some internet
Speaker one.
issue.
Yes.
Connection issue.
Speaker two for the respondent.
Yes, ma'am.
Can
Ma'am,
you? Yes.
Ma'am, the network, there has been a network issue with regards to speaker one. So may I proceed with issues 3 and 4 quickly?
Yes, please, please.
Yes,
Uh,
please.
Your Lordship, with the time constraints, it would not be possible to share my screen. So I would like to go through the arguments quickly, if you permit.
All right.
Yes, please.
Okay, so Your Lordship, issue 3 deals with whether the conviction can be upheld in the light of complete chain of custody requirements and the standard of evidence. So my arguments will be based upon what constitutes the complete chain of custody, what is the standard of evidence that has to be upheld, and with the help of facts in the particular proposition, there exists certain direct and circumstantial evidences that form a complete chain of evidence and event that leaves no other inference other than the guilt of Dr. Mehta. Firstly, I would like to talk about that the toxicology reports, PCA pump logs, and expert testimony conclusively established that an excessive dosage of morphine and midazolam was administered to Mrs. Dhumal, leading to her subsequent death. The forensic analysis has confirmed that the levels of drugs in her system were significantly beyond therapeutic limits, only enough to kill her. So, if we also take into consideration who had the access.
Council, the report only says excessive dose of
Yes,
morphine and midazolam, but
indeed, but Your
the
Lordship,
report does not say indicate that it was administered by Dr. Mehta.
that will be, I will be proving.
That you are inferring, that you are
Yes, by the subsequent following arguments, I'll be proving that. The first question is who had access to the pump? Under whose palliative care was Mrs. Dhumal? She was under the palliative care of Dr. Mehta. And by establishing that there was a prior agreement, a criminal conspiracy between Nurse Mathur and Dr. Mehta, I will be establishing that the ultimate access to the pump was with Dr. Mehta. But with regards to the prior agreement, I'll be dealing it under the subsection of, under the sub issue of criminal conspiracy. So if your Lordship will bear with me till that. So another question is that under
Just one
section
second,
1.
Council, you just mentioned that there was a direct planning
Yes,
between
ma'am.
the nurse and the doctor, and you've mentioned a case law in your Moot memo, which is State of MP versus Shitla Sahai, right?
Yes, ma'am.
Here, there is a requirement of direct evidence of planning. How do you address the absence of being any kind of direct communication or direct agreement between the three of them?
And first, we have to take into consideration the digital communication that happened on a particular messaging app. Also, there has been testimony, witness testimony of nurse and the whistleblowing of Mr. Kapoor. Also, we have to take into consideration the late night visits of Reena Mathur into the record clinic to tamper with the records. It also is in consonance with the fact that there were discrepancies in the accounts of Lifeline Pharmaceuticals. It clearly indicates that there was a syndicate running on.
No, you have to prove that Reena Mathur was acting on the instructions of Dr. Mehta.
Yes.
It is equally possible that Reena Mathur was acting independently or maybe on the instruction of Mrs.
Your Lordship,
Dhumal.
if we take into consideration the testimony of Mrs. Reema Mathur and corroborate it with the whistleblowing of Mr. Kapoor, and also corroborate with the fact that midazolam is a drug that is not sold or bought over the counter. There has to be a prescription by an anesthesiologist, and in this particular case, it is Dr. Mehta. Further, nurse is a trained practitioner, that is agreed. She can only inject the required amount of dosages in the PCA pump, but how much of it is to be administered, that is enough to kill a particular person, that expertise was with Dr. Mehta. So that is our
Again, these are
contention.
just inferences. Where is the direct chain? That is my question. These are
Yes.
again, all of these are inferences that you're drawing that only Dr. Mehta is not the only anesthesiologist in the entire country. So how are you establishing the beyond reasonable doubt this chain that there was no other person or there was no self-administration or administration by the trained nurse? How are you establishing that chain?
Ma'am, first of all, it can't be self-administered. It requires special medical expertise. And second, the ALS neurological disease that turned her almost in a semi-vegetative state made her incapable of performing such a delicate maneuver. Further, there is evidence of a spike in dosages of morphine days before each suspicious death. provided in the proposition itself. So it clearly indicates that there is a pattern that has been followed. And as also enumerated by my co-counsel under section 13 of the BSA, that further acts that are done in same circumstances, it clearly indicates that it is not accidental in nature but intentional. So with then regards to the chain of custody, we humbly contend that the prosecution has maintained an unbroken chain of custody, which requires the properly documented and preservation from the moment it is collected from the crime scene till it is presented to the court itself. In a particular case law
But
here is to be noted.
counsel, you are not able to satisfy us on the ground that the nurse was acting on the instructions of Dr. Mathur.
Uh, Your Lordship,
There is nothing in the communication. It's a routine communication. There is nothing that you attribute a criminal intent or something fishy or wrong, that he was instructing or he was guiding from Bangalore, that you have to give this much dose and this much and you have to administer. Dr. Mehta was not present. It requires medical prescription, and it is not uncommon that without prescription you also get from a pharmacy. You get all kinds of drug from pharmacy without medical prescription. This happens everywhere.
So, Your Lordship, with the question pertaining his absence from the crime scene, we have contended that it was indeed a criminal conspiracy. And under section 61 of the BSA, it is irrelevant whether the particular person was at the crime scene or not. And with regards to the procurement of midazolam, it is humbly submitted that it is not a drug that can be bought over the counter. It requires serious prescription from an anesthesiologist under whose palliative care a particular patient is. And further, if we regard the testimony of Nurse Reema Mathur and corroborate it with the testimony of Mr. Kapoor, it clearly indicates
if that prescription is given by Dr. Mathur, where is that prescription?
Your Lordship, the Moot proposition is silent on this regard, and
You are
documents.
assuming that he had given a prescription that is absent.
Your Lordship, we are stating that it can't be bought other than a prescription provided.
That is what counsel, the onus is completely on you to
Yes,
prove
ma'am.
it beyond reasonable doubt. It can't be there because of that, and hence we are inferring this is not the right argument from your end. So I am not satisfied that there is, I
Your
can't say
Lordship,
there is any conspiracy in the first place. There are no co-conspirators, there is no conspiracy at all between the three of them. I can't find any kind of link here. So can you please help me understand?
Your Lordship, we are taking the refuge of section 51 of BSA because our sole authority is in the particular case is the Moot proposition itself. So we are considering that the facts that are judicially noticeable need not be proved. The Honorable Trial Court had already considered the issue and passed an order. Further, the Moot proposition is silent on any allegations of lapses in the chain of custody, which indicates that no such issue was raised at the trial stage. Raising the argument at the appellant stage without any basis in the Moot problem itself is an afterthought and should not be entertained. So the judicial notice must be given to the fact that forensic evidences is collected, stored in accordance with the standard protocols.
But forensic evidence does not, the report and does not indicate that there was a prescription given by Dr. Mathur which prescribed this this drug midazolam. And you cannot, as per jurisprudence, criminal law jurisprudence, you cannot infer, you cannot assume something which goes against the accused, because he will be presumed innocent.
Your Lords, with regards to this reasonable doubt, I would like to present a case law of Mathura Prasad with the state of Madhya Pradesh. It states that the reasonable doubt should not be a figment of imagination or based on trivial possibilities, but should be fair and rational doubt based on the evidence at hand.
Exactly, counsel. This entire
Yes.
concept that you are presenting is a figment of imagination.
Your Ladyship, we have prepared a complete chain of evidences which clearly indicates that there is no other inference other than the guilt of Dr. Mehta. Further, in the subsequent issue, we have proved that there was indeed a prior arrangement between nurse and Dr. Mehta,
But
which
your case law
also
itself, counsel, the case law that you've mentioned, the state of MP versus Shitla Sahai, in that it is clearly, your case law clearly says that there has to be a very direct meeting of minds. How are you proving any kind of
ma'am,
meeting of mind in this communication between the three of
ma'am,
them?
we have deduced to that point by taking all the direct and circumstantial evidences as well as the testimony and corroborating all of them. Your Lordship, I think our time is up. If you may grant few more minutes, I can.
2 minutes.
So I will be proceeding with issue number 4.
Yes, please.
Okay, thank you so much. The fourth issue deals with should Dr. Aditya Mehta and Nurse Reema be liable for criminal conspiracy instead of murder? So we humbly contend that he is liable for both murder as well as criminal conspiracy under section 61, under section 101 and under section 61 of BNS. With regards to the murder, that has been dealt in detail by my co-counsel in the first issue. So I'll be dealing with the criminal conspiracy. He It is humbly contended that he was the chief architect of this conspiracy. He played an instrumental role in devising, facilitating, and coordinating the plan. Now, there exist two essentials. First is the meeting of minds, the agreement between the two parties, and to do an illegal act. Further, we're taking the refuge of an case law, MP versus Sitla Sahani, in page number 17 that your ladyship mentioned. It clearly states that often conspiracies are hatched in secrecy. Direct evidence may not be plausible to obtain, and hence reliance would be placed on circumstantial evidence. And that has been done in the present case at hand by stating the examples in the facts given, like the overdose of the drug, the presence of midazoline, Reena's late night visit to the record room, the surveillance footage, the testimonies of Dr. Nurse Reema Mathur, Mr. Kapoor, and also the strong alibi is irrelevant in this particular case because it doesn't require in a criminal conspiracy that the accused person in the criminal conspiracy has to be there. By taking this prior arrangement, the motive and the illegal act and corroborating all the testimonies, we can come to the inference that hence he was liable for criminal conspiracy. Also, I would like to highlight that all this petition, filing writ petition, filing euthanasia petition to the High Court was a act because he was a palliative care specialist. He knew that he was sorting active euthanasia. He was sorting that excessive morphine doses will be induced. He knew it would be active euthanasia, yet he filed there because he didn't want that in the future fingers will be pointed towards him. So may it please the Honorable Court that the prosecution has unequivocally established the guilt of the accused beyond reasonable doubt. Every link in the evidentiary framework, be it forensic analysis, witness testimony, or documentary proof, corroborates the irrefutable fact that Dr. Aditya Mehta is indeed guilty. If your lordship are satiated with the arguments presented, I would like to start with the prayer.
Counsel,
Yes.
but I was not satisfied with this prior meeting of mine. There was no, you could not prove that there was a prior meeting of mind with
Uh,
the facts of the case.
Your lordship, as I stated, the case of
Except that there was some communication between three, which is also a routine communication. There was nothing on
your
record to
lordship, there
prove.
was communication, and then there were act performed in furtherance of that.
And
As I already stated,
there are various other theories possible, various other
uh,
possibilities,
it
like that there may be collusion between Mrs. Dhumal and the nurse. There may be collusion between Mrs. Dhumal and Mr. Kapoor.
Your lordship, it is most humbly submitted that with our regards, we have completely disregarded all the other explainable hypotheses or possibilities. I will again take the refuge of MP versus Sheetla Sahani, which clearly states that direct evidence may not be plausible to obtain in in the conspiracy cases, and hence reliance will be put on circumstantial evidence, and that reliance has been put, and neither the reliance was
I
solely.
completely agree. I don't deny this fact that conviction can be made only on the basis of circumstantial
Indeed,
evidence.
your lordship.
But there is a process given by the court to prove the chain should be prepared and that chain should not be broken.
Indeed, your lordship, that chain is not
But
broken. Further,
there are so many possibilities which can come in between.
Your Lordship, all the possibilities that can come up, that has been come up from the side of the defense, have been negated by us. Further, we have not solely relied on circumstantial evidences entirely. We have corroborated them with other evidences as well. We humbly plead that.
How will you deny this possibility that there was a collusion between Mrs. Dhumul and the nurse Rima Mathur?
Uh,
And she
uh,
acted on the instruction of Mrs. Dhumul and she administered the dose. It is not impossible for a nurse to administer a dose of midazolam or
Indeed, Your
morphine.
Lordship. That's why Dr. Mehta came in the picture. The nurse can only inject the precise amount of dose, but how much of that morphine dose or
That can
midazolam?
also be learned. It is
I can
not
Google it
not
right now,
very
Council.
difficult for
Your,
a nurse or for
your
a judge.
Lordship, but there there can be a general instruction, but regards to a particular patient, the age of the patient, the
Now you get
particular
all
semi.
kinds of information on internet, council. What are you talking about?
But sir,
All kinds of information. Hmm.
Your Lordship, but taking into consideration the particular vitals of
And
a
how
patient.
can you held somebody liable for murder when there is a living bill by a retired high court judge, and she has a video also where she discharges
Uh,
everybody from any kind of obligation.
Indeed.
How can you held somebody for murder?
Your Lordship, as also contended by my co-counsel, the video is to be taken into the light that he was absolving all of the people that were involved, including the legal system of her death. It was not talking about taking her own life. And also, with regards to the people can Google something and administer the dose themselves, general instructions can be provided, but with regards to the particular vitals of a patient, like the degree of their vegetative states, the amount of RBCs, WBCs present, the particular blood pressure, the condition of their heart and other organs, and it is clearly stated in the Moot proposition that the dose was just enough to kill Mrs. Dhumal. So it is clearly an act of a medical professional, and in this case, it is Dr. Mehta.
But Council, there are still so many loopholes. You have not justified PCA pumps, which was only accessible by Nurse Mathur.
Uh,
Where is Dr. Mehta's
so,
involvement coming
ma'am,
in this PCA
we
pump?
have proved that by stating that there was a criminal conspiracy. There was a prior meeting of mind. There was a
You have
prior
not
arrangement.
proved conspiracy only, Council, to be very
Hmm.
honest right now. And
That was not proved that prior
so,
meet. That's why I asked prior meet. Where was prior meeting of mine?
Ma'am, as I already stated, there was testimony by the nurse herself that she was uh, being guiding under the instructions of Dr. Mehta. And also, if you take into consideration the digital communication, it is clearly evident that there was a criminal intention behind it and a prior arrangement.
can you specify which line of the communication indicates criminal
No, ma'am,
conspiracy?
not the line of communication, the testimony that was
No,
given
you
by the
just said
nurse.
now the communication between the three
The
of them clearly
the
indicates criminal conspiracy. So can you tell me
ma'am,
what?
that is an solid inference that was based on the fact that there was a messages on a messaging particular messaging app between all
It's a
these
routine
parties.
message. It only says routine message. There is
But
you can't
it
attribute
also
a
state
criminal.
that it were incomplete in nature.
Hmm.
No person operating such a overt network of mercy killing would directly write on their WhatsApp messages that they have to perform such a task. It has to be discreet and it has to be coded.
So, Mr. Counsel, you are saying direct inference. So, can inference take the shape of an evidence, conclusive evidence,
Uh,
especially in this kind of
e-
case
e-
where you are charging the person with the crime of murder and consequences are
Indeed.
huge? So, should not the standard of evidence be also equally great?
We humbly submit to the standard of proof, that is being the proof beyond reasonable doubt. And it is not only the inference, it is not only about the circumstantial evidence, but what we are corroborating it with. We have corroborated it with other circumstantial evidences, direct evidences that mandates a clear chain of events that have taken place, that allows no other inference other than the guilt of Mr. Mehta. So, if your lordships are satiated with the arguments, I would like to proceed with the prayer.
Yeah, please.
All right, please.
Wherein lights of issues raised, arguments advanced, and authorities cited, It is most humbly prayed and implored before the Honorable High Court that it may be pleased to dismiss the appeal by the convict and uphold the conviction of Dr. Mehta and or pass any other order, direction, or relief that may deem fit in interest of justice, good conscience, and equity. The councils rest their case. That will be all, Your Lordships.
I request
Thank you so much.
quick rebuttal from the side of the appellant. Can you please?
Indeed, Your Lordships, the appellants request a rebuttal for the arguments that was put forward by the learned opposing counsel.
Please go ahead.
Counsel, please do not take a lot of time, right? Wrap up
Indeed,
with
indeed. It'll be a very brief rebuttal. So the first argument that we want to rebut is the tenet of stating that Dr. Aditya Mehta was a fierce crusader and relying upon this to prove his intent. Now, being a fierce crusader, which is being time and again pointed out by the learned opposing counsel, does not mean being violent or hostile. It means being passionate about somebody's work. It is nowhere in any law stated that being passionate about your work would lead to implicate you to be suspicious about committing an offense as grave as murder. Moreover, coming to the circumstantial evidence bit, the prosecution has failed to prove beyond reasonable doubt that the circumstances align and link to the guilt of the accused. They have themselves admitted, the opposing counsel themselves have admitted in the last bit of their arguments that there were other alternate theories of death. Why have the other alternate theories of death been disregarded, and how are they being negated? That has not been explicitly answered by the prosecution, and the prosecution does have that standard of proof of proving beyond reasonable doubt. So when even there is an iota of reasonable doubt, the prosecution, it is the burden of proof on the prosecution to prove that the case is beyond reasonable doubt. They have failed to do so in the present case. They have themselves admitted that midazolam was a drug that was found, the traces of midazolam was found, but there were no explanations on how it was a drug which was not in the treatment protocol prescribed by the counsel's client, that is Dr. Mehta. How this came forth. Moreover, the reliance on witness testimonies, coming to that aspect, witness testimonies that have been relied upon are inconsistent, and Nurse Mathu's testimony has been extensively relied upon. However, the learned opposing counsels have also stated that she was a party to the criminal conspiracy. How can a co-accused be a prosecution witness and not be implicated in the trial? It is clearly stated in Moot para 24, the last page of the Moot proposition, that it was Dr. Aditya Mehta who was convicted in the present case. It is nowhere stated that Nurse Mathur got any criminal liability. Why was Nurse Mathur able to escape criminal liability? Was her being a factor or a party in this criminal conspiracy? Why were her testimonies relied upon as a substantive evidence to support the prosecution's claim? The prosecutions have failed to answer these important, pertinent questions that raise alternative theories of death on how Mrs. Dumal could have injected the medication with the help of Nurse Mathur, who is a medical professional who knows how to inject medication dosages. So now the counsels like to rest their case. It was a pleasure pleading before this court.
Very well.
The council seeks permission to proceed with the rebuttal and is deeply apologetic towards the connectivity issues.
Not an issue.
May I proceed, Your Lordships?
Yes.
Your Lordships, to begin with, the specific nature fears, the term I have used, was not to determine the intention of Dr. Mehta. It was just to establish his nature, his characteristic, as mentioned in the Moot proposition. To prove the intention, the following evidences has been relied upon. First of all, the petition of active euthanasia, which is impermissible by law. Secondly, testimonies indicating Dr. Mehta is the head of the conspiracy as claimed by Nurse Mathur as well as Mr. Kapoor as well, who themselves came in front and accepted their guilt. Moving further, forensic evidences, the specific requirement of an expert, again corroborated with the testimony of Nurse Mathur. Then prior similar occurrences, his past patients also died under similar circumstances. Further, hike just before each death. The clinic of Dr. Mehta showed an hike in para 17 just before these deaths. Further, the witness testimonies that we have heavily relied upon are not the sole evidences we are relying upon. We are also corroborating them with certain findings as well, which again empowers these testimonies as credible testimonies under Section 55 of BSA, which determines which distributes three categories of testimonies: wholly reliable, wholly unreliable, no, neither wholly reliable nor wholly unreliable. This falls under the ambit of wholly reliable, as it is also corroborated with certain other evidences. Now, moving to the specific issue of what happened with the conviction of Nurse Mathur, it is pertinent to note that the fact sheet is though silent about this. We need to go back to section 343 of BNSS 2023, where it is given the specific provision provides the prosecution and the honorable court, trial court, with the power to tender of pardon to accomplices who specifically points out the guilt of other accomplices, your lordships. This is the submission from the prosecution.
Okay. Thank you so much.
Thank you, everyone.
There is any questions for the teams or any feedback that you would want to give to the teams?
I think both the teams were excellent. They mastered the facts and the case laws relevant. So in trial cases, yes, facts are very, very crucial. So I think both the teams have done a good work. So all the best and good luck. Nobody is going to lose because this is all learning exercise in mood proposition. So it is very difficult sometimes to decide also that who did well. It may be some person will get one more mark or two more marks, so they may win the competition, but uh, ultimately the exercise is done for learning. I think everybody have learned, and it was very nice experience listening all the four councils. Thank you very much.
I would
Thank you,
say
Lord.
well articulated. So actually, all the four speakers, they have tried to do best to the brief that they had in their hands. And though I like one of them the most, I would not name. But as far as the articulation, language, the citing of authority, and the way you have presented yourself, I think you have done the best that you could. And it was really a pleasure being judge of this moot court competition. I have been judge in other competitions as well, and there also the quality participants have participated. But I would actually appreciate your patience with our questioning. So you have been grilled, and you have been grilled in a way as if you are a seasoned senior counsel, I would say, in a court. And you have actually stood to that grilling, and I appreciate that you have been able to respond well, and it was really nice experience. And some suggestion also: just don't fumble. Judges will always ask question. Don't get disheartened. Even if you do not know something, it's fair, but truthful to your brief, truthful to the case, truthful to the judge. So I think you have tried to be, you have generally stick to that standard, and all the very best. And I would say that whosoever is going to the winner, because somebody is, one team is going to win, but all of you have won our heart. And so researchers also, they have done a lot of good work, because without their involvement, the speakers might not have made such beautiful presentable briefs and prepared in a manner. So I appreciate the efforts put in by all the participants to the team, and all the very best. And you have done a wonderful work. And I think pleasure is entirely mine to be judge of this show. So all the very best.
Thank you, sir.
I would just like to
Thank you, sir.
congratulate everyone. Congratulations for coming until here. Okay, and I would not, I'll just keep it very short. I just want to appreciate all of your confidence in facing questions without fear, without hesitation. And we tried our best to confuse you and ask you questions which were not even, which were things that were very direct as well. But you really laid your ground, and you were, you were very confident about it. So really, really appreciate it. All of you, I can see that you have a great and like a really bright future. Okay. So all the best. Whoever wins, I'm not going to say the same thing, but of course, whoever wins is a different story. But all of you are winners. Okay. You're finalists. So you should really pat your back for that. Thank you, thank you. And great, great, great appreciation for Mansi and Jay for hosting it in such a great manner.
Thank you, Akanksha. Wow, that was intense. What an incredible round we just witnessed, guys. Your arguments were very sharp. The rebuttals were very fiery, and I mean, the level of preparation was truly commendable. I can only imagine how much effort and research and late night brainstorming went into this, and it showed. Um, you should be very proud of how far you've come, right? Out of all 50 teams, you've made it to the very end, and that in itself speaks volume about your dedication and your skill. So, like all the judges said, no matter the final verdict, right, you're walking away. I really hope that you're walking away from this experience as better, more confident advocates, and that is what truly matters. And a huge thank you to our esteemed judges for their time, their patience, and the brilliant insights. Your feedback and your questions, it did not just test the participants, but I'm sure that it has also helped them to learn and grow and refine their craft. We're incredibly grateful for your presence today. And to everyone who's watching the telecast on YouTube, guys, this is what mooting is all about, right? This is the thrill of advocacy, the rush of a great argument, and the lessons that you will learn along the way. Thank you so much, judges. Thank you so much, all the participants. With that, let's just take a deep breath before we move on to the results. Whatever happens next, we are just going to celebrate the hard work that you guys have done. So congratulations in advance. Thank you so much, judges. Thank you so much, Yogesh sir. Thank you so much, Anoop sir. Thank you, Akanksha ma'am. It really means a lot what all you guys have done today for us. Thank you. Thank you so much.
You're welcome.
Thank you.
We are sending the scorecard immediately.
Yeah, just
Thank you.
give 5 minutes.
In addition, judges, in case Anup sir and Professor Yogesh, if you can